Hello, 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 everyone. We are here again for episode 5 of HR Office Hours with Brad and Sandy. So, Brad, today, I had a really interesting conversation that I thought might be a great topic for us today. Great talk with my daughter, who is just entering the workforce. And she asked me about this. Mom, what's this at will employment at will? What is this about? And then the next quote, so I explained it to her. And then the next question that she had for me was, so why do they want me to give them 2 weeks notice?
Smart girl.
It didn't make sense to her, right? So
Yeah.
how about if we talk a little bit about employment at will and what that means? One thing that in speaking with managers often when they're ready to pull the trigger and let somebody go,
Mhm.
in my world, it's my first question is, okay, so where's the documentation? Have you been, has this been moving forward? Have you addressed the performance? Often there's not a lot of documentation. And the question that I get is, well, we're employment at will. It doesn't really matter. I can let somebody go for any reason or no reason.
Yep. Wow. There's lots to tackle there. We probably could carve 3 or 4 episodes out of just your opening comments. But yeah, employment at will, right, is the notion that either the employer or the employee can end their relationship at any time and for any reason, so long as it's not an illegal reason, right? And that means really fundamentally, so long as it's not a discriminatory reason or that you're not doing anything else wrong, but the discrimination or the potential for discrimination claims are, or can end up being the tail that wags the dog, then that goes to your point of, well, where's the documentation? Because what we need to document is that we are terminating this person for legitimate, non-discriminatory business reasons or other reasons, but that aren't based on, the person's membership in a protected class, they're having blown the whistle on some impropriety in retaliation for something that they may have done or alerted management to, or filing an EEOC charge or something like that. So, but at will employment is sort of the standard here in the United States, and it's not necessarily elsewhere in the world. And there is one state in the US, I think it's Montana, that the default is actually not employment at will, but I don't deal with Montanans a lot, so I don't know the particulars, but I think pretty much everybody in Montana has an employment contract that guarantees them a period of employment. It's my understanding. But for the rest of us in the US, it's employment at will, which means you can leave anytime and or the employer can terminate you anytime, and again, for any reason. But it just can't be one of those discriminatory reasons. And so that gives both employers and employees a lot of freedom. But it also comes with some other sort of obstacles, and we'll talk about those in a sec. With respect to your daughter's question, it's a very good one. Well, if they can terminate me at any time, why do I have to give them 2 weeks notice? Well, you really don't. I mean, employers will often frame that as a requirement, but the reality is, you can walk and, what are they going to do? So it's, oftentimes we encourage employers to mate a 2-week notice requirement with an agreement to pay out PTO, right? Sort of a little bit of a you scratch our back, if the employer is not otherwise.
So if you
give us the notice, the 2-week notice, we'll pay out your PTO or some portion of it. You know what I mean?
Especially in Florida, because there's no requirement for that. So
correct. Yeah. Some states have yeah, exactly. But if you're in Florida, where both you and I are, it's kind of the Wild West with PTO, and you can do what you want with it. So
that would kind of help. I mean, the detriment for an employee for walking out and not giving the 2 weeks is also when that employer will get that phone call about, I guess the question would end up being, are they eligible for rehire?
Mm-hmm. Yeah, and obviously that could have implications there. And if a person answers no, then yeah, and that's maybe a whole other topic, is dealing with communications post-separation. But we kind of wanted to distinguish, because the US system is a little bit unique, right? In most other places in the world, and you can have it here in the United States too, you can have term employment, right? Where you can have a contract that guarantees a person, employment for a year or employment for a year, and then it'll roll over to another year and another year. And then there will need to be specific reasons, typically characterized as quote unquote cause for a termination or giving individuals the option to terminate without cause under certain circumstances. So there are ways you can bake in some more protections, both for the employer and the employee, that guarantee a term of service, with some off ramps baked into a contract. But again, that's a special contractual relationship. The default for your average worker in the US is an at-will relationship, and we encourage most of our clients to memorialize that in their offer letters, that hey, this is an at-will relationship. Their handbook should reiterate that too. It's an at-will relationship, and that gives them the flexibility. On the other hand, and to your point, Sandy, about the documentation, we'll often have employers call us and say, hey, we need to terminate this person. It's got, it's a little messy for X, Y, and Z reason. And we'll say, well, confirm that it's an at-will relationship, or send us all the documentation. And they'll go, yeah, it's at will. And then they send us an employment contract. It's like, well, no, actually, we have to sort of adhere to this. And you're only going to be able to. Yeah.
Can we talk about that? Like, what if you are doing an employment contract?
Mm-hmm.
What should it look like? Because I do have, recently, have a client has operations in Canada, where
Mm-hmm.
that is the norm.
Yep.
Having an employment contract is the norm, and so can we talk about that a little bit?
Yeah, and maybe we put a pin in that for a more elaborate sort of follow-up conversation. But with respect to what the contract should look like, how many colors are in the rainbow? I mean, there's no one size fits all, right? And you can have an employment contract that fundamentally memorializes an at-will employment relationship, right? Maybe you want to put some restrictive covenants, some other IP protections in place, some confidentiality, some specific provisions, but you could still have that. You could have a contractual relationship that is nevertheless fundamentally at will. It just needs to say as much. Alternatively, typically you would have, if you really want to have that term commitment, meaning a period of time during which the employer is obligated to employ the employee, and vice versa, you would have just that, and you would have it for a set period of time, typically a year or 2 years as an initial term. And then oftentimes you'll have an evergreen where it rolls over automatically unless either party gives, 60 days, 90 days advance notice of an intent not to renew. And, there's any number of provisions you could put in a employment contract, right? Severance is one reason that oftentimes people will have an agreement in place on the front end. And you typically see this for higher level employees, right? If we want to bake in what the sort of exit path is going to be for a person, if they leave us, under these circumstances, then they'll get, 3 months severance, or 1 month severance for every year of service, or 1 week for every year of service, whatever it may be. And severance is obviously not a feature of all contracts, but certainly at the higher level, with executives, which we often deal with, you'll have severance as a component of a employment agreement.
Yes, and if you're doing that, let's not forget all of what we talked about on episode 4.
Yeah.
Right.
The NLRA, changing the game on that. So the NLRB, excuse me. Yeah.
They're having a good time. I wonder if it'll ever change here with employment at will. I was unaware of Montana, so I'm super interested in that, and I may look up some HR pros in Montana.
Yeah.
Because I wonder how that works. I mean, there's a lot less people in Montana, so it would be hard to compare. I guess you could do per capita. What are the EO charges? How's it compare?
Right.
A really employer friendly. I don't know if that's employer friendly or employee friendly.
I think it probably cuts both ways. And, kind of where I wanted to finish this conversation was comparing, the standard at-will system here in the US with, you mentioned Canada, and we work with clients in Canada. We've done a lot of cross-border transactions where clients are buying businesses in Europe, that involves employee, acquisitions or some layoffs. And, oftentimes that's a sort of, I won't say rude awakening, but it's a wake-up call as to what the requirements are, because those people all typically have, even if they don't have employment agreements, just the standard operating, employment law landscape in European countries is, a person is guaranteed employment, or if they're going to be terminated, they get, so many months advance notice, and then they get paid for so long after the fact. Just, for an ordinary course termination, which in the US, you could fire somebody tomorrow and you never have to pay them another dime. And that's just a major difference. And what we've done here in the US to sort of try and protect employees, from the downsides of at-will employment is we've created all these laws. You can't discriminate on this basis or this basis or this basis or this basis, and they're all extremely well-intentioned, and there are great policy reasons for them having been developed. But then where employers find themselves, occasionally is sort of in this, spider's web of, well, I feel danged if I do and danged if I don't, and I feel beholden to this, and you get claims brought that are wholly unmeritorious, but there's a cost to defense, and now you're paying people to. So we sort of end up in the same place in some ways as those countries or societies where there's that longer guarantee. Although on balance, I think U.S. employers get off a little easier in that regard. But it's it's an interesting exercise to just sort of compare and contrast how we do it here versus what they do elsewhere.
It really is. It makes me think that perhaps, and some of my experience in helping managers navigate, one of the things that I find myself saying is like, why aren't we having a conversation about this issue? Like, why are you coming to me before you've addressed this head on, a performance issue? For example, somebody thinks that their employee is sleeping, with the office door shut.
Right. It's like, can I fire him? Well, probably, but can we deal with this? Can we knock on the door first?
Well, can we say, hey, this happened, it makes me think that you're sleeping at your desk. I think what if there could be a medical issue or something that requires an accommodation, right? Which is the fear of, oh my God, something's going to happen and I can't make a misstep.
Yeah.
It prevents, I think sometimes it prevents us from having these authentic and real conversations that we need to have with our employees, right?
Yep. And that was my point, that these laws began really well intentioned, but what they've ended up doing is sort of having employers feeling like they're being held hostage, and that the government's right. I mean, everyone's got views about government and good, bad, or indifferent, but I think oftentimes in the employer space, and even as an employer side lawyer, I help clients navigate these things, but I find myself being frustrated, oftentimes by
our own laws,
right, and process sort of taking precedence over substance, and employers feeling like they really are held hostage. So good, rich topic, and probably something we could tackle further in another post. But been good to see you, Sandy, and
always great to see you, Brad.
We'll do it again next time.
All right. Have a great day. Join us next time. Like and share. And join us next time for episode 6 of HR.
Look forward to it.
All right. Have a great.
You too.